They had the intention of killing all of these people that night. They succeeded in just one of them.
Barbarian, child killer, and he will serve his time.
If you choose for me to die, it's only going to cause more pain and suffering for another family, not me. It won't hurt me. I won't feel anything.
The case against Byron Frazier began on Christmas night in 2012 in Ohio. Prosecutors say a family dispute escalated during the holiday, involving Frazier, his stepsister Keela Shields, and her boyfriend Adam Dieters. After the initial argument, Shields and Dieters left to visit a relative. Later that night, Frazier allegedly arrived at the same location where a shooting occurred. Shields was and Dieters was injured, but managed to call for help, identifying Frazier to authorities. Frazier was charged with murders and attempted murder, but his first trial was disrupted in October 2013 when an emotional outburst erupted in the courtroom, forcing the judge to declare a mistrial. A retrial began months later under tight security.
The motive, and unfortunately, it's a sad motive. So we have the motive, we have the forensic evidence, and we have the bad guy. They had the intention of killing all of these people that night. They succeeded in just one of them. Fortunately for us, we have the other to testify.
The defense argued that the evidence does not prove that Frazier is the shooter.
But the defendant had been disrespected earlier that night at a party. The defendant and his father had been disrespected earlier that night at a party. And they didn't like it. They weren't going to take it from this girl. So they're going to shoot her and kill her.
We're not disputing that someone is dead. We understand that's a tragic thing. But what the evidence is never going to show is that Byron Frazier had anything to do with it. There's never going to be a smoking gun, if you will, in this case. None of the evidence is going to be able to tip the scales from innocent until proven guilty to guilty.
During the retrial, the jury found Byron Frazier guilty. He was sentenced to 32 years to life in prison for the of Keela Shields and the attempted killing of Adam Dieters. The Ohio Court of Appeals later reviewed the case and upheld both the convictions and the sentence. Tanico Thompson was in a relationship with Carl Patrick, a Miami police officer, and the two lived together in his home in Pembroke Pines, Florida. Prosecutors later said Thompson falsely claimed she was pregnant and used Patrick's credit cards, which led to growing tension between them. On a morning in May 2014, an argument took place inside the home. During that incident, Patrick was shot in the arm. Thompson claimed it was self-defense, saying she feared for her safety. Instead of calling for immediate medical help, she left the scene. Patrick was later found inside the house and pronounced dead. Medical testimony revealed that his injury was survivable if emergency help had been called in time. Thompson was arrested and charged with second-degree murder. At trial, her defense maintained that she was a victim of domestic violence and acted to protect herself.
I wish that that morning never happened, although Carl was the one that initiated the argument. I'm sorry in my own self-defense that Carl lost his life with Patrick. I truly loved Carl.
Prosecutors rejected that claim, arguing the evidence showed no immediate threat and emphasized her failure to call 911. In 2016, a jury found Thompson guilty. At sentencing, family members from both sides spoke.
She is a good person. So what I'm trying to say here is give her a chance.
He felt that she was so special. Little did he know, one day she would have taken his life from him.
She was being kicked out, so she took his life. There's no penalty high enough for what this woman did.
It's the considered judgment of the court that the defendant will be remanded to the custody of the Department of Corrections for her natural life.
The sentence not going to bring my son back, but she won't be hurting another person or killing another person.
Tanico Thompson was sentenced to life in prison. She showed little reaction as the sentence was read. Patrick's family said the ruling brought them a measure of justice, knowing the person responsible would never harm anyone again. In the early hours of October 1st, 2020, Detroit police responded to a burning vehicle and found the body of Takoya Moore, a 31-year-old father. While officers went to notify his family, they found Moore's girlfriend, Isis Rimpson, and Moore's son, Tyers Moore. inside the basement. Investigators quickly linked both locations and determined the deaths were connected, turning the case into a multi-scene homicide investigation. Police arrested Nicholas Rodbiri, a 37-year-old from West Bloomfield Township with a prior criminal record.
Your name, please.
Nicholas Rodbiri.
Prosecutors charged him with 15 offenses, including multiple counts of first-degree murder and firearms violations. He was denied bond and remained in custody as the case moved through the courts.
Barbarian, child killer, and he will serve his time. It was all about drugs and money.
And I don't wish this on anyone, our pain and grief. And we just want to thank you all.
Police said the evidence pointed to drugs and money as key motives, noting that Nicholas Rodbiri searched online for luxury items shortly after the crimes.
A monster. He's a monster. He's a monster. He ain't showing no remorse.
He was just a jolly, smart kid.
Very much.
And I just don't understand, how can you kill a 6-year-old?
Family members remembered the boy as bright, joyful, and deeply loved. In April 2022, a jury found Bari guilty on all counts. At sentencing, the judge imposed life in prison without parole. In January 2014, Justin Back, an 18-year-old from Ohio preparing to begin his future in the U.S. Navy, spent time at his home with 2 longtime acquaintances. Police determined that Austin Myers, then 19, and Tim Mosley were responsible for Justin's death. Both were arrested and charged, and the case quickly moved to trial due to the seriousness of the allegations. At trial, co-defendant Mosley agreed to testify and received a life sentence, while Myers faced the possibility of the death penalty. A jury ultimately found Myers guilty of aggravated murder. During the sentencing phase, Myers took the stand and addressed the jury directly, apologizing to Justin's family and asking that his life be spared, saying another death would only cause more pain to innocent people.
I'm sorry that this happened. Now, I know that doesn't bring Justin back, but I'm sorry. I hate for any family to go through such pain and suffering as this. If you choose for me to die, it's only going to cause more pain and suffering for another family. Not me. It won't hurt me. I won't feel anything. It's going to hurt more innocent people. The terrible events of this past January have caused more than enough pain already. If you kill me, it won't fix anything. It won't bring Justin back. It's only going to hurt more innocent people. I don't want to hurt people. So all I'm asking you for is a chance for me to become a better person.
After deliberations, the jury recommended the death penalty, a decision later upheld on appeal, placing Myers among the youngest individuals on Ohio's death row. In November 2009, in Rising Sun, Indiana, Connor Conley, while their parents were at work. Later that day, Andrew left the house and went to the local police department, where he told officers that something had happened to his brother. He then led investigators to an outdoor area near a park, where Connor was found. Andrew was taken into custody, and the case quickly moved into the court system. Because Andrew was a juvenile at the time, the legal process focused on both accountability and his age. He later admitted responsibility and entered a guilty plea. Andrew addressed the court, apologizing to his family and the community, and expressing remorse for his actions.
I would like to start by saying that I am very sorry for my little brother, and I will never forget him and how much he meant to me and how much he meant to so many people. I still have no idea why this happened, but I really wish that I did. I go to sleep every night and I wake up every morning, and I wish I could change what happened.
After reviewing expert testimony and legal arguments, the judge sentenced him to life in prison without the possibility of parole. The case later went to the Indiana Supreme Court, which upheld the sentence, bringing the legal process to its conclusion. The case involving John Strutz began in 2009 in Delhi Township, Ohio, after his wife, Kristen Strutz, was reported missing and later found dead. Investigators determined her death was not accidental and quickly focused their attention on Strutz. Based on evidence gathered during the investigation, he was arrested and charged, and the case moved to trial the following year. During the trial, Strutz chose to testify in his own defense and denied responsibility for his wife's death. As prosecutors presented key evidence, Strutz became visibly emotional in the courtroom, reacting strongly while listening to testimony.
We had the lower portion of the abdomen, we had the pelvis, and we had the upper parts of the thighs. This also matched the known tattoo present on the back of Kristen Strutz. It does not lend itself to being believed that she died of a natural death or an accidental death when someone takes it upon themselves to try to destroy the evidence as to how she died.
The judge found Strutz guilty on multiple charges related to the case. Strutz was sentenced to 26 years to life in prison with eligibility for parole in 2035, bringing the trial to a close, though Strutz has continued to maintain his innocence in the years since. The case began in 2014 in Cincinnati, Ohio, when Josiah Eves, a boy, was taken to the hospital after suffering serious injuries. Josiah was the son of the girlfriend of Amond Rainey, who was caring for him at the time. Rainey told investigators the boy had been hurt in an accidental fall while brushing his teeth. Medical findings, however, raised concerns, and the Hamilton County coroner later ruled the boy's death a homicide.
To see a 2-year-old bandaged up and laying there fighting for his life, lifeless, in a coma, breathing machine, it doesn't make sense to us.
Based on that determination, prosecutors charged Rainey with murder, and he was held without bond as the case moved forward. After charges were filed, Rainey was briefly on the run for several days before turning himself in and appearing in court for the first time. During that appearance, his father publicly defended him, saying he believed his son was being judged too quickly.
If we thought that he was capable of doing this, we would not be standing behind him. We would not be trying to embrace the fact that he did not do it. All the comments that are made or speculations of, because I mean, it's a 2-year-old, people react, emotions are high, but the point is he's a laid-back, quiet guy.
In a surprising moment, Josiah's mother was also seen supporting Rainey in court, though she did not speak publicly. Years later, the case went to trial. A 3-judge panel ultimately found Rainey guilty of murder. On September 1st, 2025, police were called to a home in Hazel Park, Michigan, after concerns were raised about the residence. Inside, officers found Linda Hill, 41, and her son, Cardi Jackson, unresponsive.
Blood was also splattered on the south wall of the living room. Officers discovered the female Linda Hill to have a deep laceration to her neck.
A relative who had been in the house reported hearing noises earlier and called for help when no one responded. Investigators later learned that Linda had been on the phone that day and said she needed to hang up because her brother had arrived, prompting police to treat the situation as a homicide investigation. By the next day, detectives identified Linda's brother, Vladimir Keith Hill, 43, as a person of interest. Police located him at a home in Pontiac, where they also found evidence connecting him to the scene. Family members later told investigators that Hill returned briefly to the house after police had already been there and asked for forgiveness before leaving again.
See, we got everything. We got the 4 wires, but we don't have the 5th wire. Why? Because we don't know. And until we get that, we can't have closure, right?
On September 5th, Hill appeared in Hazel Park District Court and was formally charged with 2 counts of first-degree murder. He entered a not guilty plea and was denied bond, meaning he will remain in jail as the case moves forward. If convicted, Hill faces a possible sentence of life in prison without parole. The case against Calvin McKelton began in 2008 when investigators in Butler County, Ohio, connected him to 2 deaths. Prosecutors said McKelton was responsible for the death of his girlfriend, Margaret Missy Allen, and later for the death of Jermaine Evans Sr., a man they believed had information about what happened. Authorities argued the second was meant to keep Evans from speaking to police. McKelton was eventually indicted on multiple aggravated murder charges, setting the stage for a high-profile trial. When the case went to trial in 2010, prosecutors planned to rely on testimony from Michael Nix, a key witness who had previously spoken with investigators. However, when called to the stand, Nix refused to testify, even after being ordered by the judge.
If you wish to tell the court why you do not wish to testify, are you afraid for your life?
And the court believes that there has been a well-documented pattern of intimidation, threats, and outright violence against witnesses in this case.
The court acknowledged concerns about witness intimidation, but allowed jurors to hear Nix's earlier recorded statements instead.
Calvin had told him that there was an argument that got out of hand, and he didn't mean to do it.
Despite the setback, the trial continued, and McKelton was ultimately convicted on all major charges. His case later reached the Ohio Supreme Court on appeal, where the convictions and sentence were reviewed in 2016, bringing the case to its final legal stage. Over the past 2 years, juvenile crime numbers have remained relatively stable, but judges say the real concern lies in what is happening inside the courtroom. In 2024, there were 539 reported juvenile violent cases, and by October of the following year, that number stood at 514. While the overall figures have not changed dramatically, Judge William Cruz Shaw says the court is seeing the same youths return again and again, often after violating probation or release conditions. Recent hearings highlighted this pattern, including a juvenile already on probation who was taken back into custody for a new incident, and another juvenile who returned to court after failing to follow court rules.
You were on my probation, and you're at the Riverwalk acting a fool.
We are seeing the same kids escalating, so that therefore we have to, get a little bit more tough in terms of consequences to those behaviors. If the crime is severe enough, they can go to prison. And we need for them to understand that. This is not a game.
Judges say the system provides support services to help juveniles and their families, but progress depends heavily on parental involvement.
Parents are saying, I no longer want my child, or they're making comments about they just can't do it anymore.
Judge Shaw expressed concern that some parents are disengaging, telling the court they feel unable to manage them anymore. While the court's goal remains rehabilitation, judges are making it clear that serious or repeated behavior can lead to stronger consequences. In 1986, Wilda Wilkinson, a nurse's aide in Bangor, Michigan, was found inside her home after failing to show up for work. The case immediately drew attention, but investigators struggled to find enough physical evidence to move forward. A neighbor, Michael Leon Curry, was identified early as a person of interest. In the years following the crime, Curry allegedly made multiple confessions. Prosecutors at the time declined to file charges, believing the evidence did not meet the legal standard needed for trial. The case remained unsolved for decades, while Curry served a long prison sentence for an unrelated crime and was later released in 2017. Renewed attention came when the Michigan State Police Cold Case team reopened the investigation, reviewed old records, and re-examined Curry's past statements. Investigators said Curry later provided additional detailed admissions, prompting authorities to seek an arrest warrant.
He was listed as a person of interest in the original investigation.
More than 30 years after Wilkinson's death, Curry was arrested and charged, finally bringing long-delayed accountability to a case that had lingered for generations. The case began on October 30th in Wayne Township near Hamilton, Ohio, when emergency crews responded to a fire inside a foster home. Investigators later said a boy, who had been living with the foster family for about a year, started the fire in his bedroom while 5 adults, including his foster parents, were inside the house. No one was killed, but authorities determined the incident was intentional, prompting a serious juvenile investigation. In early November, the bot appeared in court for the first time, where prosecutors outlined the charges connected to the fire, including multiple counts of attempted murder, aggravated arson, and a misdemeanor domestic violence charge.
Do I understand correctly there are 5 counts of attempted murder, 1 aggravated arson,
and then 1 domestic violence misdemeanor. Are there any kind of charges pending up there in Franklin County at this time? No.
Both his foster mother and biological mother were present during the hearing. Family members later told reporters the boy had faced significant challenges growing up and described his past as troubled, expressing hope that the system would focus on treatment rather than punishment. The court ordered the boy to remain in juvenile detention while a competency evaluation was completed. By December 20th, the court determined the boy was competent to proceed. On that date, he agreed to enter a plea in juvenile court, accepting responsibility for the charges tied to the October incident. In February 2015, Allison Feldman, a 31-year-old medical sales professional, was living alone in a quiet Scottsdale neighborhood. When Allison failed to respond to messages the following day, her boyfriend grew concerned and drove to her home. After entering with a key, he noticed signs that something was wrong and called emergency services. First responders arrived and found Allison deceased inside the house. Police secured the scene and began an investigation. Detectives determined that Allison had been attacked inside her home and that several personal items were missing. There were no clear signs of forced entry, and investigators were initially unable to identify a suspect. Despite extensive interviews and evidence collection, the case went unsolved and eventually became cold. Among the evidence recovered was DNA belonging to an unknown male. At the time, that profile did not match anyone in criminal databases. Years later, advances in forensic technology allowed investigators to re-examine the evidence. In 2018, that process led police to focus on Ian Mitchum, after a relative's DNA showed similarities to the unknown profile. When Mitchum's DNA was compared directly to the evidence from the crime scene, it matched. Police arrested him and charged him with first-degree murder and burglary. The case then entered a long legal delay. Defense attorneys challenged whether the DNA evidence could be used, arguing it had been improperly retained from an earlier, unrelated arrest. A lower court initially agreed, but prosecutors appealed. The dispute eventually reached the Arizona Supreme Court, which ruled in late 2024 that the DNA evidence could be admitted at trial. With that decision, the case finally moved forward. Jury selection and testimony began in late 2025, more than a decade after Allison's.
Morning.
Good morning.
Can you hear me okay?
Yes.
Could you introduce yourself to the jury, please?
My name is Elisa Smaltz.
Can you spell your last name again?
Smaltz.
Are you currently employed?
I am a part-time contractor for the city of Peoria.
Okay, what are you doing for them?
They needed assistance with verifications of their technical casework and latent prints, so that's what I do.
Prior to that, were you employed by the city of Scottsdale Crime Laboratory?
Yes, I was.
And when did you go to work there?
I started there in 2006 and worked there until the end of the last day of last year when I retired.
All righty. Can you give us a little synopsis of, well, first of all, let me ask you this. Over the course of your career at the Scottsdale Crime Laboratory, tell us a little bit about what you did, starting from the beginning up until your retirement.
Well, I was first hired as a latent print examiner in their latent print unit. The latent print unit soon thereafter was put in with the crime laboratory, so our titles changed to forensic scientists. And I worked my way up through the ranks, becoming a forensic scientist supervisor, and then after that being promoted to the forensic laboratory manager.
Okay. And as the manager, what did you do?
I oversaw all the disciplines in the Scottsdale laboratory.
And when did you become the manager?
In 2018.
Tell us about your education, training that allowed you to do the jobs that you have done.
I started working as a crime lab analyst for the Maricopa County Sheriff's Office in 1992. I worked there until I went to Scottsdale in 2006. While I was at the Maricopa County Sheriff's Office, I processed crime scenes. I did latent print comparisons. I processed evidence from those crime scenes in the laboratory. I did APHIS entries and comparisons, and back then we developed our own film.
Okay. Things have changed.
Yes, much so. And then after that, like I said, I went to the Scottsdale laboratory, and I did latent print comparisons. At the Scottsdale laboratory, the latent print examiners do not respond to the scene unless they need specialized assistance. So my primary function at the laboratory as a latent print examiner was we processed evidence in the laboratory, and we compared those prints to known subjects.
You, before I forget about it, you mentioned a term, APHIS,
Yes.
AFIS, I believe.
Yes.
Can you explain to the jury what that is?
It's a database. APHIS stands for Automated Fingerprint Identification System, and it's a database that houses many known exemplars from people who either have been arrested, who are trying to obtain a license for various reasons, whether it be like real estate license, teachers, that sort of thing, and then also applicants for government work. They're all housed in that database. And what that does is if there is a latent print out at the scene or that we develop in the laboratory and we do not have a subject, or the subject that they gave us when we compared it to them, if we determine it wasn't that person, we can still try to identify it by placing it into that system to search against all those known exemplars in the database.
You mentioned a moment ago that ordinarily, unless requested, latent print examiners, at least at the Scottsdale Crime Laboratory, would not respond to a crime scene, correct?
That's correct.
So was much of your work as a latent print examiner done actually in the laboratory itself?
Yes.
I don't know if this applies to everyone here, but I would think that at least it's possible that when someone mentions the term latent print, they're thinking of fingerprints, which would be the case. But also sometimes do we leave prints on surfaces from other parts of our body?
Yes, there's friction-ridged skin is what makes up a fingerprint or a friction-ridged print. And you have them on your hands and on the bottom of your feet.
And is it just the tips of the fingers or other areas of the hand?
No, it's the entire hand, your surface here. Fingers, the fingertips, the length of your fingers, and the palm.
Thank you. And so if I walk across a surface barefoot, I might leave ridge detail.
That's correct.
And I think I had Ms. Metz explain friction ridge detail yesterday, but let me go ahead and ask you to do the same.
Friction ridge skin, everyone has it. If you look at your hands, you have like ridges and furrows. Biologically, it's there so to assist someone in gripping, and there have different breaks and minutia in there that identifies that print to you uniquely.
Assume for me that we've had a description of the process of, on occasion, lifting a latent print that has been found on an item. That lift is taken to the crime laboratory where you worked, and you were asked to compare that lift to known print impressions, okay?
Yes.
So you mentioned that, for example, someone might apply to become a teacher or other government position, and in order to get licensed, they have to submit prints, and those prints, images of those prints at least, are put into the APHIS system, correct?
That's correct.
Maybe someone on the jury has never been fingerprinted, but let me have you describe, for example, if I had to come to the crime laboratory because I wanted to become a teacher, I was required to have my known prints taken. How would that happen? How would you accomplish that task?
You would go to a designated location in which they offer that service. For instance, for a license, as you described, most likely you would be printed using black printer's ink and a paper stock card that has a place for all 10 fingers rolled and placed directly straight onto the card. But if you were, for instance, being arrested, most likely it's now live scan. It's done digitally. It's a piece of glass on a station in which they roll those prints and they go directly into the database.
Digitally?
Digitally, yes.
Okay. When you're in the laboratory and you're asked to do a comparison between a latent lift from a scene, to known prints, how do you go about doing that?
The first thing I do is I check to see if they have any fingerprint record on file. If they do, most likely I can retrieve those digitally. Sometimes agencies have files that are the way that I described before, using black printer's ink. So I would do my best to try to locate a known fingerprint record for that person.
And then how do you go about determining if those match or not?
I first, with the latent print, the first thing I'm going to do is I'm going to look at it to see what kind of detail is there. Is there even enough there for me to conduct a comparison? The next thing I'm going to look at is to see anything like if there's distortion in that print so that I can take that into account when I'm doing the comparison. So I analyze that print and I notate, mentally the uniqueness of that print. And then I take the 10 print record that I have on the subject that is to be compared, and I start looking for the target group that I've memorized in my head. Like I look at the print, I pick out a certain area of the latent print with the detail, and I'm trying to locate that in the area, the 10 print card or the palm, depending on if it's a 10 print or a palm. And if I see an area in the exemplars that looks similar, then I go and take a deeper dive look into that print, and I start comparing the minutia to see if they're in the same relative position in the same area of that print until I'm satisfied that either it is that person or if that person can be excluded.
Now, you told me, if I understood you correctly, that on occasion you might be called to crime scenes, correct?
That's correct.
In fact, when you were with the sheriff's office, that's what you did, right?
Yes.
So imagine you're at a crime scene and you're looking at an item, a tabletop, for example, and you are your task is to see if there are any fingerprints, palm prints, footprints, whatever on that surface. Is the only way that you can preserve what you find by that latent lift process, or do sometimes you photograph the
Yeah. Yes. Okay, so when I'm going to process an area, the first thing I determine is what is the surface I'm processing? What kind of surface is it? Is it porous? Is it non-porous? Is it textured? Is it wood? Is it glass? That sort of thing. And then that will allow me to determine which process is best to use on that surface. So there's physical processes such as the black powder method lifting, and then there's chemical processes as well. So, for instance, if there's a surface that's more textured, or a print may be in something other than like normal sweat or perspiration, then I'll pick a chemical process, which there's various ones. There's some that's specifically for blood, and there's some that all I'm trying to do is preserve any print that may be on that surface. And for instance, super glue method, it's cyanacrylate, and what happens in that process is that area is, the super glue is fumed. Those fumes are allowed to deposit on the surface, which then hardens those prints and preserves those prints. And then subsequent chemical process, like liquid chemicals, can then be applied without washing them away. And then those will be looked at like under a forensic light source to be able to visualize, and then you would photograph those.
Would it be possible for you to preserve a latent print that you find at a scene, get it back to the laboratory, and in looking at it, then determine there really isn't, it's a print, but there isn't sufficient ridge detail to do any sort of comparison?
Absolutely. Because typically when you're at the scene, you're just trying to collect as much as you can. It's really not the time for you to do any specific analysis on those prints.
All right, I want to take you back to February of 2015. On February the 19th of 2015, what was your assignment in the laboratory?
I was a forensic scientist supervisor at that time.
And I neglected to ask, when you do your work, either going to a scene, processing an item within the laboratory, what sort of records do you keep of your work? Anytime
A request is submitted and I do any type of examination, then I author an examination report. And during that examination, I also take notes. So the documentation would be my notes plus the report.
And when you, for example, if you responded to a scene and you collected latent prints that could potentially be compared, are those what you lifted or collected from the scene, are those maintained in the crime laboratory? And what I'm getting at here is, for example, a latent print card, which Ms. Metz explained yesterday. Are those preserved within the laboratory?
Yes.
If you take a photograph of, you develop a latent at the scene and you take a photograph of it, are those preserved in the laboratory?
Yes.
I want to take you to February the 19th, 2015. Did you respond to a scene at 8526 East Monterey Way within the city of Scottsdale.
Yes.
Now, why did you go to this scene?
I was requested to respond to the scene to see if there was any assistance I could provide regarding footwear and friction ridge detail that perhaps could use additional processes that the crime scene specialists could not do.
Now, I'm going to ask you, ma'am, over this morning to go through a number of reports that I believe you authored. And for your assistance, Exhibit 33, which is a large binder, is there. If you need the opportunity to review one of your reports to refresh your recollection about what you did, let us know, and that can take place. But before I do that, so do you remember going to this scene?
Yes.
And when you arrived, tell us what you did. I mean, initially, what you did.
The first thing I did was spoke to detective there to see where I could enter the residence. Once I was able to enter the residence, I was able to, they showed me around to see the things they had in mind for me, and I offered my opinion on how I could help them.
Okay.
And so after that, after I obtained that information, then I was able to determine what supplies I would need.
And when you enter, when you entered into this scene, are you wearing any protective clothing of any sort?
Yes.
And what would that be?
We wear something called Tyvek suits. It's a special suit. They're usually white. And so I would have the booties, a full suit, a bonnet on to cover my head, my hair, and a mask.
Okay.
And gloves.
And gloves. All righty. I know it's been 10 years ago or so, actually a little longer than that now, maybe, but what do you remember, if anything, about what you saw or smelled when you entered the residence?
I entered the residence through the side, which entered like a little, I don't know if it was a pantry area or a storage area that then led into the kitchen. So that's the route I entered. I did not enter through the front door. The first thing that caught my eye was the amount of blood that was on the kitchen floor, and a like white, appeared to be liquid at some point, residue on the floor in the living room, and a strong odor of, the only way I could describe it is like bleach or chlorine or something like that.
Okay. So you mentioned a moment ago that you spoke with a detective, you entered the residence, observed the scene, and then you suggested to the detectives what you might be able to do, correct?
Correct.
And so what was it that you determined that you thought would be the best utilization of your skills?
That I would look for any footwear or friction ridge evidence within the blood that was on the kitchen floor and on the floor of the living room.
So what, if anything, in terms of footprints, foot impressions, ridge detail on the floor, could you see any, first of all, just visually?
In the living room, once I actually got down there with the flashlight, yes, I could see that there was some ridge detail, but I wanted to enhance it so that I could see it better. That was in the living room. And in the kitchen, I believe I saw some impressions using a flashlight and some just within the blood that I wanted to enhance.
How did you go about enhancing what you observed?
I did both physical and chemical processes. So I did black powder. Well, first of all, I photographed what I could see first. Then I tried black powder, and I tried a chemical that reacts to blood.
Now, after you said you took photographs, would those photographs have been retained?
Yes, I personally did not take those photographs. The crime scene specialist took the photographs at my direction.
All righty. And then after utilizing the chemical processing, might that allow for a photograph to be taken to make it the image itself, the ridge detail, more apparent or obvious?
Yes.
And when we look at a photograph of an area of, let's say, the living room floor, and after the chemical processing, we have some images I'll show you, not right this moment, but they have a distinctive color. Why is that?
That is from the chemical that I used. For example, the ones in blood would be blue after I apply the chemical that I use for that. The ones that aren't in blood, you'll see it has a yellow hue because that dye stain is yellow. And when I use the alternate light source to visualize that, you'll see the image, the ridge detail in yellow, like fluoresce.
Earlier this morning, you explained the glue process.
Yes.
So what was that term again?
Cyanacrylate.
Yeah. All righty. Can you spell that?
It's
okay if you can't.
CYANOCRATE.
Thank you. I thought that might help the court reporter. That's why I asked. So did you do that within the home that day?
Not that day.
Okay. When did you do it, if you did?
The second day I responded.
All right. So how did you go about doing that?
For the area in the living room, because the area was so large, for instance, in the laboratory, when we typically do super glue fuming, we have a chamber that does that. So at a scene, which the floor was much larger, I had to create a portable tent. So what I did was I took traffic cones and I placed them around the area of the floor that I wanted to process. And I placed plastic across those cones to create a tent. And then I proceeded to do the super glue process, which involved, I had a portable heater, a hot plate, in which I applied super glue into a tin dish and placed that on the hot plate. And I heated that up within that sealed tent that I made. And I also put a humidifier in there because the super glue needs humidity in order for it to adhere to the surface. So I humidified the area, then put the glue in there to heat it up so that it would fume, and I let that fume for a while and then took it out, and then I had to then clear the house and for it to air out.
The chemical.
Yes, the chemical needed to air out.
And then were photographs taken of any ridge detail that you observed?
Yes.
Did you find, or did you observe, do you recall observing any apparent sock prints in the kitchen?
Yes.
Did they appear to be within the blood?
Yes.
And when you described them as apparent sock prints, what was it that you saw that made you believe that?
It was, I observed like an outline of a foot because I could clearly see like the outline of what appeared to be toes and then the rest of the foot. And there were linear lines, a linear pattern within that impression. And they were all parallel. The lines were parallel along from the what would be the heel to the toe, and they were just in rows, which friction ridge is not like that.
And when you were observing this, I mean, you mentioned there was blood on the floor, but were you able to determine if the sock print was there first, or the blood was there first? Was that possible?
It appeared to me that the sock was there after the blood.
Did you also observe what you believed would be shoe prints on the tile floor in the kitchen?
Yes.
And did you process those and cause them to be photographed?
Yes. Those were photographed and lifted with a gel lift.
Okay, explain that process for us.
So we did various processes. Like I said, I tried to powder it. I applied chemicals, and I also lifted the impression with a gel lift. A gel lift is merely similar. It's similar to a latent print card. Like,
might that have been either Hans or Palma?
I would assume, yes.
When you processed what you observed and you saw potential ridge detail or a sock imprint, did you label them or cause them to be labeled in some fashion, and then a photograph taken?
Yes.
And what label would you have been using?
I used L for laboratory so that those could be differentiated from the evidence that the crime scene individuals were collecting. So we laid out little paper cards in the location of each imprint or ridge detailed area so that those could be photographed.
Okay, ma'am, I'm going to show you a few photographs that have previously been admitted into evidence. And the first one I'm going to show you is Exhibit 514. Can you explain to us what we are seeing here?
In this image, you can see the traffic cones that I described to you earlier, which assisted me in creating a tent. And there is the placard L5 displayed there. And you can also, in that image, you can see the hot plate that I was describing to you with the tin, with the super glue. You can see that the super glue has changed color because it was heated.
So this object that I'm pointing to on the
Yes.
cone?
Yes.
And so this particular photograph, then it sounds like would have been taken after you had utilized the super glue.
Yes.
And in the chair back here, this plastic sheet, you know what that is?
It looks like plastic, but I don't recall if that was the plastic that I used. It could have been, but I don't recall.
All righty. In order to process this area, did you have to cause the couch to be moved?
Yes, so that we could get in there to move around and be able to build the tent.
Showing you Exhibit 306. Describe for the jury, please, what we're seeing here.
Those are areas of interest that we labeled that were going to be photographed. You can see all the little paper placards there with the cones again that I described were used to build the tent. Right here towards the front of the photograph is the forensic light source that was used after I applied the liquid chemical onto the surface after the super glue. And
what is this apparatus?
That is the forensic light source.
Okay.
And towards the top of the photograph, up against the chair, is broken down pizza boxes. Again, like I said, I was trying to do things that are typically in the laboratory out at a scene. So in order for me to visualize those prints with the forensic light source, I needed that area to be completely dark. And as you can see, that big window there, it was producing too much light. So I literally was trying to cover that area with the extended out pizza box to not allow the light in, and so that I could use that light source to look at what was produced after I superglued it and applied the chemicals.
Showing you Exhibit 307. This particular area of the, well, first of all, does this appear to be that living room floor?
Yes.
This surface is, one looks at it, might think it was wood, but was it wood?
No, it was the hard tile that's made to look like wood planks.
There's an area here in the middle of the photograph. I'm not sure how to describe the color, but it's clearly different than the other parts of the floor. What can you tell us about that?
That was the chemical that I spoke to you about previously, it's a yellow colored dye stain, which was applied and will adhere to the friction ridge that has been preserved with this super glue process.
Showing you Exhibit 304, which is in evidence, I see a placard that is L5A. What information does that provide us?
There's friction ridge detail in that print. You can see that the friction ridge detail is brighter than the yellow background.
Yeah. For those who aren't seeing what you're describing, trying to get it, it's hard to get it on the screen. So you see the ruler, it looks like.
Yes, and probably from the jury's vantage point, it just looks like linear ridges that's to the right of that scale.
Here?
Yes.
Okay.
Yes.
What did it appear to be at the time that you were looking at it?
It appeared at the scene, like I say, I don't try to particularly analyze it, but it was a larger area, so I assumed it had to be a palm or a foot.
And Exhibit 305. Now here, for the purposes of the record, I'll just say it looks yellow to me. The other 304 appeared to be orange or red. Why is there a difference in the colors?
It's just the lighting and the exposure that the
Prosecutors argue that the DNA evidence, combined with other investigative findings, places Mitchum at the scene. The defense has acknowledged the DNA match, but maintains that Mitchum is innocent and has pointed to alternative explanations and other potential suspects. The case has drawn attention not only because of the length of time it took to reach court, but also because of its reliance on familial DNA, a method that played a key role in reopening a case that once seemed unsolvable. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.